Hi, this is David for 10 on tactics for tacticsandtrials.com. Please remember to subscribe and to like the video. Also, if you have any questions, please leave them in the comment section below. Today, we will review the 2011 case from the Ninth Circuit Court of Appeals, Glenn v. Washington County, 673 F3D 864. The court reversed a district court grant of summary judgment for deputies who shot and killed an 18-year-old Lucas Glenn, a suicidal, intoxicated man who was armed with a small knife. The Ninth Circuit held there were triable issues about whether the use of force was objectively reasonable and whether the officers were entitled to qualified immunity. The case is now an important Ninth Circuit decision on excessive force where the subject was emotionally disturbed and was armed. Since this was the summary judgment stage of the proceedings, if facts were disputed, the Ninth Circuit accepted the plaintiff's version of the facts. On September 15, 2004, around 3 a.m. in the morning, Lucas Glenn returned home intoxicated and agitated after a football game. He began to destroy items in his grandmother's home, and he held a knife with a 3-inch blade and threatened to commit suicide. His parents called the police asking for help with their intoxicated and emotionally disturbed son. Dispatch told responding deputies that Lucas was suicidal, intoxicated, and he had broken a window at his grandmother's house. Dispatch also advised that he was armed with a small knife. The bigger concern was that the Lucas's grandmother's house had hunting rifles in the home, but that they were in a locked case. Allegedly, these rifles were not accessible to Lucas, according to his parents. An off-duty deputy who was in the area arrived first. He had been working a special assignment in the local area. He immediately approached the house and took out his gun and pointed it at the area where Lucas and an unidentified male were standing. He was about 8 to 12 feet from Lucas in the driveway. A second deputy arrived shortly thereafter. Both officers drew firearms and loudly issued commands. At some point, officers fired a less lethal beanbag round at Lucas. Soon thereafter, when Lucas failed to follow any commands and it appeared to deputies that he was going back into the house where his family was located and the rifles were secured, they fired lethal rounds that struck Lucas. He died on the porch. There was evidence that before the beanbag rounds were fired, Lucas had not been moving from the position he occupied when officers first arrived. The court held that Lucas only moved after being struck by the beanbag rounds and his movement was non-volitional. The family and several eyewitnesses contested whether Lucas had advanced toward the house or even posed an immediate threat to them or others. Following the incident, Washington County Sheriff's Department concluded that the deputies followed agency policies and that they were not at fault for the death of Lucas. However, the attorney for the plaintiff retained an expert who opined that the deputies' actions escalated the situation and failed to utilize other less lethal compliance tools such as tasers. The district court concluded that there was no constitutional violation as a matter of law. The Ninth Circuit disagreed and reversed. As to this stage of the proceedings, the Ninth Circuit identified several disputed points that precluded summary judgment. 1. The fatal shooting is the highest level of intrusion by a government actor. The court noted Lucas's conduct, as interpreted in the plaintiff's favor, was less than active resistance, and that the deputy's own policies might have characterized his conduct as not warranting deadly force. 2. Critical to a Graham v. Connor analysis is whether the subject posed an immediate threat to officers or others. The record contained conflicting evidence. Officers argued Lucas moved toward the house door where the parents were located and thus created an imminent threat to the parents. However, eyewitnesses and the plaintiff argued Lucas had not advanced and that any movement occurred only after the beanbag round had impacted him, possibly non-volitional movement. Because these facts were disputed, the court held summary judgment was not proper at this stage of the proceedings. 3. The court discussed the officer's tactics and pondered about the appropriate tool to be used in that scenario, beanbag versus taser versus other tactical tools. Interestingly, the court considered whether the police tactics escalated the static situation. The Ninth Circuit recognized Diorel versus Rutherford, a prior Ninth Circuit less lethal use of force decision, as a relevant precedent on the risks of less lethal munitions and the need to account for the subject's emotional disturbance in the Graham calculus. The court noted disputed evidence about whether the officers knew tasers were available and whether beanbag deployment was reasonable under their own agency policy. The court concluded the defendants were not entitled to qualified immunity as a matter of law at summary judgment. The court explained that whether force was excessive, a constitutional violation, and whether that violated clearly established law are distinct inquiries. Here, because factual disputes remained about the threat Lucas posed and the reasonableness of escalation, immunity at summary judgment was inappropriate. The Ninth Circuit therefore reversed the district court's grant of qualified immunity and remanded for trial. After remand, the case was tried. A jury returned a verdict for the plaintiff and awarded approximately $2.5 million in August 2012. Below are the principal ways Glenn has affected law enforcement practices in the Ninth Circuit. 1. Glenn is frequently cited for the proposition that when certain facts are genuinely disputed during the summary judgment portion of the proceedings, and those facts are pertaining to A. whether a subject posed an immediate threat, B. whether the subject's movement was volitional, thus making him more of an imminent threat, or C. whether there were alternative tools or tactics feasible at the moment of the encounter, courts should not resolve excessive force claims at summary judgment. The Ninth Circuit's careful parsing of those factual disputes is now routinely cited in subsequent Section 1983 cases. 2. The opinion stresses that beanbag rounds and other less lethal weapons can escalate the encounter. The use of less lethal tools must be analyzed in the context of deoral when encountering emotionally unstable individuals. 3. Glenn is often cited where plaintiffs survive summary judgment because the Ninth Circuit emphasizes that factual disputes about the objective reasonableness of force can defeat a claim of qualified immunity at summary judgment. 4. Police trainers use Glenn and its discussion of use of force escalation, equipment choice, and interacting with emotionally disturbed persons as a caution that policies must A. prioritize tactics that de-escalate emotional crises, B. clearly train officers about the appropriate circumstances for the use of less lethal and its limitations, and 3. require awareness of how deployment of less lethal munitions can change subject behavior and the risk calculus involved in a use of force. Glenn shows the detailed and in-depth analysis courts will perform to scrutinize the precise facts about the subject's movement, the commands given by the officers. Detailed and in-depth analysis courts will perform to scrutinize the precise facts about the subject's movement, the commands given by the officers, the warnings provided, and if there were any less lethal options available. In many instances, well-documented incident reports with accompanying body cam and car cam videos are decisive in resolving disputed facts. The instances, well-documented incident reports with accompanying body cam and car cam videos are decisive in resolving disputed facts. The court stressed the need for training in crisis intervention, and less coercive tactics can reduce the risk of deadly outcomes in litigation. The court also warned about the use of less lethal munitions since they may escalate the situation. Glenn is a detailed specific case, and it does not create a bright-line rule forbidding particular tactics, but it emphasizes that when the evidentiary record contains conflicting accounts about whether an individual posed an imminent threat, particularly one involving an allegedly emotionally disturbed suicidal drunk armed with a knife, the reasonableness of deadly force cannot be easily resolved during summary judgment. For law enforcement agencies, the ruling bolsters the importance of utilizing available resources for a peaceful resolution and to have proper training for all officers regarding the use of less lethal tools. This is David for tacticsandtrials.com. Until next time, be safe.